Hello boys and girls. Today we'll be looking at Unit 1, Judiciary, Part 2. Moving on with Attorney General. Attorney General is the first legal officer of the country and he is appointed by the President of India under Article 76 of the Constitution. And Attorney General can be in power until the President is in power. That's what it says, can hold the office during the pleasure of the President. And in order to be qualified as Attorney General, he must have the qualification to be appointed as a judge of the Supreme Court, and the work of the Attorney General is to advise the central government of India on legal matters, and he can perform other duties as it is assigned to him by the President. And he has the right to audience, which means he can appear in the courts on behalf of the central government. One thing. Second is that he can take part in the proceedings of the Parliament without getting a right to vote. So these two things is what we mean by right to audience. And like how we saw a district judge can have additional district judge based on the workload, likewise the Attorney General can also be assisted by Solicitor General and 4 additional Solicitor Generals. And the position of Solicitor General and additional Solicitor General is not provided in the Constitution, but it is enacted in the Parliament through rules and acts. Moving on to Advocate General. Advocate General is similar to Attorney General. The only difference between them is that Attorney General works for the central government, but whereas the Advocate General works for the state government. And he is a senior law officer of the state. And according to Article 165 of the Constitution, Advocate General is appointed by the Governor. And he is the chief legal advisor of the state, and he performs duties and he also represents the state in the courts, and he takes orders from the governor as and when required. And the qualification for Advocate General is that he should be able to become a High Court judge. And the office of Advocate General is held during the pleasure of the governor. As long as the governor is in power, the Advocate General can also be in power. And the remuneration means nothing but the salary. The salary of the Advocate General is decided by the governor, and depending upon the workload, he can also have additional Advocate Generals to assist him in the office. So the difference between is that I have given some tabular column, you can just check it out. The Attorney General is appointed by the President, whereas the Advocate General is appointed by the Governor. Here it is Article 76, there it is 165. And the qualification for Attorney General is to become a judge of Supreme Court, whereas for Advocate General it is to become the High Court judge. He gives advice to the Government of India, whereas he gives advice to the state government. He is assisted by Solicitor General, and here is assisted by additional Advocate General. Can hold office during the pleasure of President. Here it's the Governor. He can represent the court on behalf of the central government. Here he represents the courts on behalf of the state government. He is the first legal officer of the country, whereas he is the highest law officer in the state. The resignation submitted to the President, and here the resignation submitted to the Governor of the state. You always have to know that whomever appoints you, you can submit your resignation only to the concerned person. So here for the Attorney General, it is the President who appoints him. So therefore, the Attorney General submits his resignation to the President. And for the Advocate General, it is the Governor who appoints him. So therefore, he is submitting the resignation to the Governor. Moving on to the roles of Supreme Court. The Supreme Court primarily exercise two things. First is adjudication of dispute, which means they solve the disputes. Disputes means the problems, cases, whatever comes before them, they give the judgment. That is what it means, adjudicator of disputes. Okay. Next is interpreter. The meaning of interpreter is understanding. It understands is what's an interpreter. So understanding of what? So if there is any confusion in the Constitution by the governments, and it will be the Supreme Court who will clarify the doubt on the Constitution. So that is what we mean by interpreter. Okay. So moving on with original jurisdiction. Original jurisdiction is the first jurisdiction, the first role of Supreme Court. The meaning of the word original jurisdiction is that the first time the courts can take up the case is what we mean by original jurisdiction. The original jurisdiction will differ from courts to courts. Since here we are talking about Supreme Court, it is the original jurisdiction of the Supreme Court is that when there is a problem between two governments, which means if there is a problem between two state governments, or if there is a problem between a state government and a central government, or if there is a problem between a state government and a union territory government, then they can approach the Supreme Court directly. They don't have to go to the district courts, or they don't have to go to the high courts. They can directly approach the Supreme Court. So according to Article 131 of the Constitution, so Supreme Court is granted the original jurisdiction. And next is, you can just see, and such disputes must involve some question of law or fact on which it can be, the legal rights can be adjudicated. For example, the river dispute between the states. Now you will be aware of the problem that's going on between Tamil Nadu and Karnataka for sharing of river water. So it is a problem between two states. So therefore they can directly approach to the Supreme Court. So this is what we mean by original jurisdiction. Please understand that each court will have a different original jurisdiction. So original jurisdiction means the first time, what type of cases for the first time the courts can hear is what we mean by original jurisdiction. Okay. So moving on to next is we have writ jurisdiction. We all know what is a writ. So writ, there are various writs like habeas corpus, quo warranto, mandamus, prohibition, certiorari. These are the writs which you would have studied in your 11th standard. So these type of writs the Supreme Court can give away. So according to Article 32 of the Constitution, it provides that citizens can approach the Supreme Court for enforcement of various fundamental rights, and these fundamental rights can be brought by the Supreme Court through issuing various writs. So this is what we mean by writ jurisdiction. Moving on to next is appellate jurisdiction. Appellate jurisdiction is nothing but whenever a court gives a judgment. For example, let's take High Court. Whenever a High Court gives a judgment, and if one of the parties is not okay with the judgment that's given, it's not happy with the judgment, then they can go for an appeal. So where will they go? Usually when you go for an appeal, you go to the higher courts. So when you already have gone to high courts, and if the High Court has given a judgment and you're not happy about it, you go to the higher court than the High Court, which is the Supreme Court. So here it is appellate jurisdiction can be invoked by a certificate granted by the High Court. So one thing you have to note is that simply anybody cannot go to Supreme Court for appeal. So the High Court should give you a certificate. Only when a High Court gives you a certificate, you can go for an appeal to the Supreme Court. Otherwise, it's not possible. So appeal to Supreme Court may be made against any judgment, decree or final order of a High Court in both civil and criminal cases, which means, see, now we are looking at a new term known as judgment. You probably know what's judgment, but I don't know whether if you know about what's a decree or an order. So in order to look at this, we'll just move on to next slide, and then again I'll come back to this slide. So I will explain you this judgment, decree and order in terms of a story. Now you see, let's take, there is a father who has two sons, and the father dies suddenly, and the two brothers, now they are fighting for the property owned by the father. So who should be taking the property? There is a fight between the two brothers, and using the power, the elder brother takes all the property, and he does not give any property to the younger brother. So younger brother does not have any house, he is left out with no property, so therefore he moves to court. Now after filing a case, it takes some time. So the court does not immediately give the judgment for the case. It takes some time for the court to give the judgment, because there is a lot of pending cases in the court. So first is the order. Let's look at the order. Now you see, when the proceedings are going on, if the younger brother is requesting the court saying that, my lord, I don't even have any house to live, so please ask my brother to allot me a house until the case will be decided. If the younger brother is making such a request to the court, then the court may order the elder brother to give one house until the case is being decided. So it is an order, which means now the court is ordering the elder brother to give one house until the case is solved. So it does not mean that the court has completely transferred the ownership of the property to the younger brother. It does not mean like that. Only until the case will be decided, he can be in that house. So this is what we mean by, we say like interim measure. Interim is nothing but short time solution. So until the case will be decided or adjudicated, the younger son can have a particular house to live. So this is what we mean by order. So this is an order. It's not a final judgment, but rather it is only a meantime, a short time, a temporary solution is what we mean by order. Next is judgment. You know what's a judgment? Judgment is what the judgment the court gives. For example, in this case, now after some many years of proceedings, many years of this case, the court gives a judgment saying that both sons has a share in the property. If the court gives such a judgment, then it's not over from there. So now you have to go another step, like say decree. That's what is decree is. Now decree is a detailed version of a judgment. So which property will be taken by whom? For example, you are aware that some property may be in a very city area, or some property may be located in a very backward area. So depending upon the area, depending upon the geographical location of the property, the value of the property might change. So now decree is a detailed version of judgment saying that which property will be owned by whom. For example, like say a house which is located in the city will be taken by the elder brother, or a property which is located in the outskirts of the city will be given to the younger brother. Something like this will be divided by the courts, which is given in detail, which is what we mean by decree. So order is an interim measure, a short time temporary solution given to one of the parties. Judgment is what is the overall judgment of the case is judgment, and decree is a detailed version of the judgment is decree. I hope you understood this concept in terms of a story. Again, moving on to the concept of appellate jurisdiction. Now, when can you go for an appeal is that when a case must involve a substantial question of law. There should be something about law. There should be some question of law, substantial question of law. Only then you can go to Supreme Court. As I already said, you see in the first point it said it should be invoked by certificate. There is a certificate required for you to move to Supreme Court. Simply everybody cannot go to Supreme Court. So there is a certificate should be given by the High Court. So, and there is also exception to it, as you see in the last point. Under Article 136 of the Constitution, the court may grant a special leave to appeal, which means that sometimes you can file a petition to the Supreme Court asking to take the particular case. Irrespective of whether certificate was given or not, sometimes you can file an appeal, file a petition to the Supreme Court. Maybe it may be in the High Court or it may be with the District Court. You can file a petition. You are simply requesting it. If the Supreme Court is interested in it and if it thinks it is important, then the Supreme Court may take up the case irrespective of whether you have certificate or not. If the Supreme Court is satisfied that it is important to take the case immediately, then they may take the case. That is what we mean by special leave to appeal. So no need of any formalities like getting a certificate, all such things is not required, is what we mean by special leave to appeal. So the special leave to appeal, you can go, you say in the last point you see, receive any judgment or decree, determination, sentence or order in any cause or matter passed or made by any court or tribunal in territory of India. So you can go for appeal for a case which has been decided in India, in any maybe in the courts or maybe in the tribunal, you can go for appeal. So moving on to next is advisory jurisdiction. Advisory jurisdiction is nothing but advising. So Supreme Court advises the President of India if the President of India asks for it. So according to Article 143 of the Constitution, the Supreme Court can provide a advice to the President. This is known as presidential reference. So the President may refer any question of law or a fact of public importance. President may seek advice from the Supreme Court. Now it is to note that when the President asks the Supreme Court for advice, it is not mandatory for the Supreme Court to answer. It may answer or it may not answer, depending upon the question, what type of question is asked. So it is not mandatory. That's why it says it's not binding on the Supreme Court to answer the questions raised in the reference. The Supreme Court may refuse to answer if the question is involving a socio-economic in nature or if it is in political in nature. Then for all such cases, then the Supreme Court may remain silent. It is not required to answer. So next is public interest litigation. Public interest litigation is where a public files a case on behalf of someone else. As the word clearly says, public interest litigation. You know what is litigation? Litigation is nothing but a case, a suit is what we mean by litigation. So usually when will we file a case? When we have a problem personally, we go and file a case. But what if you are not the problem, but someone else is the problem and you are no way related to the problem and you are not the victim or you are not anybody, you are not even in the case, but still you can file because if you are interested in the general public, then you can file a case. That's what it says, public interest litigation. Okay, so or it is also called as social action litigation. It is called as extraordinary jurisdiction. So Supreme Court has permitted the public spirited persons and civil society organizations to approach the court on behalf of the victims for better administration of justice. See, I will be able to court. I will be able to move to court if I have a problem. But there are some people in the society who are poor or who does not have enough knowledge or who does not know how to approach a court. So there are still people like that in India. For those people, if they are in some problem, then on behalf of them, I can approach to court on behalf of them. This is what we mean by public interest litigation. So in this regard, the Supreme Court has relaxed the locus standi. The locus standi means that the right of a party to appear and be heard by a court is what we mean by locus standi. So it's not necessary always for the concerned party to be present in before the court. So it's not required. So anybody can file a case and judgment will be given, and that judgment will be applicable to the concerned person. So it's not always like the person who is involved in the case has to be present in the court. It's not like that. So that's why I say the Supreme Court has relaxed the locus standi. So next point is that the court on its own initiative started cases of public importance. We'll look at that in the next slide, I guess, which is known as so motu. We'll look at that. Sometimes it's not like somebody has to go and file a case. Sometimes the Supreme Court itself can take up the cases on their own if they think it is important to take. So the first public interest litigation was filed in 1979. It's known as Hussain-Ara cartoon, which is the state of Bihar, for the inhuman conditions of the prison in Bihar. So we'll look at that in another video where I will be discussing about all the cases in this unit 1. So this is the first case that was filed in as public interest litigation, Hussain-Ara cartoon, with the state of Bihar, where there was no proper toilets, there was no proper rooms for the prisoners, and many prisoners were there for many years without even hearing. They were serving their sentence for many years. So all such problems were happening in that Bihar prisons. So a public spirited citizen, Hussain-Ara cartoon, filed a case for it. Okay. Now moving on to this, public interest litigation can be used on socio-economic rights, legal entitlements, environmental issues, political reforms, and for all such matters. So what are the characteristics of public interest litigation? So public interest litigations are seen as tools for social change. So when economically backward people or people who does not have enough knowledge to move to court, they may be easily vulnerable to some problems. So when the court gives others an opportunity to file a case on behalf of someone else, now it is acting as a tool for social change. So next point is expanded the rights to third party to represent the victim in the courts. Yeah, that's what I said. It may not be necessarily me who is involved in the problem. It may be someone else, but I can go and speak on their behalf. So the court has let the third party to represent the victims in the courts, so which is a good thing. Third point is that public interest litigations are creating a new rights and laws within the realm of the state. These laws are also democratizing the citizens' access to justice, thereby strengthening the democracy in India. So, whenever a public spirited citizen comes up with a case, comes up with some problem which is affecting majority of the people, then the court can make laws. Since we have adopted common law, that's what we saw in the previous video. We have adopted common law, and in the common law, the courts can make laws. If the government or if the legislature fails to make a law, then the courts can make law. So through public interest litigation, the court makes such law and it's creating new rights and laws for the state. Okay. Moving on to next thing, public interest litigation further strengthens the role of judiciary as a monitor and watchdog agency. So watchdog agency means that the court makes sure that if there is anything happening, anything bad is happening in the society, then it lets others to come front and complain about it. So it's making sure that it's watching what's happening in the society. So if there's a problem to be addressed, it will address. So it's acting as a watchdog agency of the democracy. It has improved the conditions of jails, protective homes, mental asylums, and etc. as we spoke. Okay. Next point is public interest litigation also been misused for private gains, litigation or on unnecessary issues, also criticized for judicial overreach and stepping into the shoes of legislature. So whenever you take something, there will be good and also bad. Likewise for public interest litigation also, simply just because you can file a case, people have started to file case unnecessarily. So which has led to a lot of pending litigations, which already the court is having a lot of cases. Through this public interest litigation, for everything they start to file a case for it. Okay, so examples of public interest litigation cases is that you can go with bonded labours matters. Yeah, I think you should be knowing what is bonded labour. Bonded labour is nothing but where you are asking someone to work as a slave, is what we mean by bonded labour. So sometimes with a very less salary, sometimes with a very less wages, or sometimes even no wages, no proper shelter given to them. So all these things is known as bonded labor matter. Okay, like something like a slave, you have to work for 10 years for repayment of like rupees 2 lakhs or 5 lakhs, something like that. Okay, and next is neglected children, or petitions against police for non-filing of cases, or petitions against the atrocities of women. For all these types of matters, you can file a public interest litigation. So matters like, see now look at this, matters like landlord tenant problems, petitions related to pensions and gratuity will not be entertained. So all such things will not be entertained as a public interest litigation. So moving on to next is suo motu actions. So that's what we said. Sometimes I told you that on its own, Supreme Court on its own can take actions for certain problems, which is what we mean by suo motu. Suo motu in the Latin term meaning it's on its own motion. So it can initiate legal proceeding based on newspapers, based on media reports, telegrams or letters received by the aggrieved people. The court can take up a case on its own. Nobody is required to file a case. If the Supreme Court thinks that if it's important to take up the case, then they will take up the case. Okay. So next is the legal aid. Legal aid is that giving persons of limited means or grants or for nominal fees, advice or counsel to represent them in the court for civil and criminal matters. So in simple terms, legal aid is nothing but you are providing free legal services to the victim. Legal services in the means you give legal advice, you represent them in the court without any fees, you do all the document work without getting any fees. So all this is what we mean by legal aid. So if a person belongs to the poor section of the society and he is having an annual income of less than 18,000 rupees, annual income means per year if you have less than 18,000 rupees, or if he belongs to scheduled caste or scheduled tribe, then he is eligible for to receive the legal aid. So in the legal aid chapter, we will be looking at in detail about the criteria for receiving legal aid, but here is just a small information. So you can get legal aid who is someone really poor, a woman, a children who is affected by natural calamities. There are some industrial workmen, there are some criteria for it to receive legal aid. If you fit in that legal aid, if you fit in the criteria, you are eligible to get a legal aid. So amicus curiae. Amicus curiae is something more or less related to legal aid. It is a Latin term meaning friend of court. For example, take a case. There are two parties. If one of the parties does not have a advocate to advocate on his behalf, then the court may appoint an advocate on his behalf for free. So this is what we mean by amicus curiae. So all these things in detail we'll be seeing in the last chapter. So I think with this we will stop with this content, guys, and we'll continue in the next video.